Good afternoon. Good afternoon. We are back. 2 p.m. Eastern Time. Remember, every Sunday, 2 p.m. Eastern Time, we're here for a live session. All to catch up, on the latest immigration news, answer questions, and, just talk about everything that is going on. So we're here live. Hello, how are you? Let me know in the comment section. Let me know in the comment section. How you feeling? Let me know in the comment section. How are you? How you feeling? I'm just waiting for a couple people to get in so we can get started. Let me know in the comment section how you feeling. I'm posting, I'm sharing the link on my IG so that we can get some people. Okay. So what is going on? A lot is going on. We want to talk about the latest immigration news. I'm going to share my screen in a moment. Try to adjust my lightning. Okay. I'm going to share my screen in a moment, but if you have a question, just please put it in the comment section. We're here for live session and we're here to answer a couple questions. Okay. So what's going on? Let me share my screen. So we can get started. So if you go on immigration policy tracking project .org, you will see all the latest immigration news, right? And the Trump 2.0. You see here 2.0. So we're looking at what's going on. The latest is this. The news came out on February 6, 2026. What exactly are they saying? They have established new procedure for appeals at the BIA level, new procedures for appeal. The main thing here to remember or to keep in mind is that dismissal will be the default. Okay, once you submit your appeal, they might just dismiss it unless the board members decide to take upon your case. Okay. So that's the default, is a dismissal. Almost like a waste of time. But anyway, let's see. It says here, the rule implements the following changes, okay? Establishes that the default for appeals will be summary dismissal. That's the default. You file for an appeal, they just dismiss it. Unless a majority of the current BIA members vote to consider the appeal on the merit within 15 days of filing the appeal. So they want the procedure to go just as fast as it can go. Back in the days, you file for appeal, you wait 2 years, 5 years. Now you file, they might just dismiss it. If they don't dismiss it, they'll consider it. And once they consider it, you have to provide the briefing, your argument basically, and they'll decide. It's not going to take that long anymore. Shorten the time for filing an appeal with the BIA from 30 days to 10 days. Yeah, you got to file for appeal within 10 days of the immigration judge decision, except for certain specified asylum appeals. Certain cases, you might file within 30 days, but the default is within 10 days. For non-dismissed cases, requires simultaneously briefing within 90 days of the BIA setting the schedule with no reply brief and limited extension. Yeah, if they accept your case, well, then you have to file your argument within 20 days. So it's no longer going to be the way it used to be, like you wait for the court to schedule your briefing, filings and stuff like that. You know, people have been waiting for 2 years, 5 years. Now what they're saying is that it's going to go just like that. And it says eliminates the requirement that immigration judge continue to review transcript of the oral decision before adjudication of appeal. So in other words, you just file the appeal with what you have, because back in the day, you will request the transcript and you see what was the mistake. Then you can file a thoroughly appeal, right? But now it looks like, yeah, you just file with what you have. Removes or revise provision authorizing the chief appellate immigration judge to either extend adjudication deadline in particular cases or to hold cases based on pending action. Yeah, and then they go back to alien, right? Yeah, so basically the goal here is to provide the decision quicker so that they can address the backlog, because we have at least 4 million cases pending. It just keep going up, so they want to go as fast as they can. So in reviewing appeal and allowing it to focus, they're now focusing on appeal with particularly novel or complex legal questions. If it's new or it's complex, if it's just, oh, because the immigration judge did this, did that, they're probably just going to dismiss it on default, and you're going to have to go to a circuit court of appeal in your state, basically where your immigration case was pending, in order to get a federal judge to review, in order to file a petition for review. So it's not going to be that easy anymore. Basically, that's what they're saying. Appeal is just going to get dismissed. It's just like almost like the waste of money. So, do we have questions so far? Do we have questions so far about this appeal? The new ruling of the appeal. Do we have questions? In other words, what they're really saying is this: when the person only has, it's going to have only, and that's going to start on March, right? Not March 9, I guess. But anyway, the person only has 10 days to submit, to file for an appeal with the BIA after the immigration judge enter a decision. Only 10 days. And most likely it might get dismissed because that's the default, unless members of the BIA decide to take upon your case. And once they decide, then you have 20 days to submit your argument. That's it. So, and then they're going to make a decision. It's not going to take that long anymore because of Trump deportation plan, mass deportation plan. They just want to accelerate those decisions so they can have final decision on those cases. Yeah, so the question becomes now, should I file for an appeal or not? I mean, just that's up to you, because it's just going to be really hard to win those appeals. But when a person files for an appeal, at least they preserve their issue so that they can have a chance to file a petition for review if they choose to do so with a federal court. So yeah, that's what's going on. That's the first news. Let me see the second news here. Now they just want judges, it's almost like asylum is dead, to be honest. This one says that wow. So yeah, immigration's getting harder and harder, with those new rulings and stuff like that. So this one says, let me share my screen again here. Hi, Arthur Frankowski, 16B. How are you? How are you feeling? Do you have a question? You can put your question in the comment section while I'm talking, and then I can revert back to it. Let me share my screen here. Okay. This one says that Bloomberg Law reported that top immigration court officials have instructed newly hired judges to grant asylum only in rare circumstances. So the asylum is just going to get denied only in rare circumstances. According to the people familiar with recent DOJ training sessions, they recruit many of them military lawyers. Remember that they put military lawyers in immigration courts as judges, temporary judges, short-term appointment, and they've received instructions to just deny those asylum cases, to grant only in rare circumstances. So in other words, you really have to have evidence, strong evidence, in order to win asylum. Recruits were also encouraged to adjudicate cases quickly and advised to deny asylum without holding hearings, you see. Judges must adhere to performance metric established in 2025, requiring them to hear 4 to 6 cases per day, more than 3 per day standard at Biden. But now they just wanted them to go as fast as they can, denying those cases. So you really have to have a lot of evidence when you're applying for those asylum cases, because your case might be assigned to a new judge who has a military background on a short-term appointment. Yeah, and with those instructions, yeah. So those are the things to consider basically when a person is filing for those asylum. Okay, so we have another one. This one. Here it says that DHS uses administrative subpoena to obtain critics' personal data. Yeah, if you're criticizing this administration, they can obtain your data and pretty much retaliate, in my opinion, right? So the Washington Post report that DHS is increasingly relying on administrative subpoena to obtain personal data from technology companies, universities, employers, and social media platforms. Former official and expert estimate DHS issues thousands, possible tens of thousands of the subpoenas each year, often approved quickly by mid-level official. Yeah, and shield from public accountability. Yeah, in recent months, that's what I'm saying. If you're too much of a critic to this current administration, then they're gonna get your data and pretty much like take actions against you, right? DHS has used them to seek information about student protesters, workers, and healthcare system critical to ICE actions, and person posting online about enforcement activities. So basically, if you are criticizing this administration and you posting about things that are happening when it comes to ICE enforcement, um, those ICE raids, those ICE, arrests and stuff like that, you keep posting them on social media, while the Department of Homeland Security is going to get hold of your data. And if something is not good in your background, they're just going to file a case against you. So those are the things that if somebody has a petition pending, they just have to avoid it in order to just sell smoothly, right? Stop sharing here. Let's see. Do we have a question? Do we have questions? Okay, we have a question here. Included in what? They're included. I mean, in terms of what do you mean if they're not included? If you file for an appeal on March 9 with the BIA, just know that the default is the dismissal. So the BIA is just going to dismiss the case unless the Board of Immigration Appeal they vote on taking the case. So starting March 9, if your case is not on appeal yet, that's fine. But sorry, if the case is already on appeal, that's fine. But if you file a case on March 9 with the BIA, the default is just a dismissal. So that's what it means. Everybody's included if the case goes on appeal with the BIA. Everybody's included. Unless the case is currently pending. So let's say you file something with USCIS, it gets denied, you go to immigration court, it gets denied, then you file for an appeal with the BIA. Well, the default is just a dismissal. They just don't want to take the case, basically. That, in other words, right? So if they vote that they're gonna look on your appeal, then you have 20 days to submit the argument. So that's what the rule is. So everybody's included unless you already filed your appeal before March 9. Yeah, everybody's included. Okay. Let me continue with the news. Yeah, there's a lot going on here. This one. DHS enter into a 15 years consent decree with Florida to curtail exercise of parole authority. Basically, they don't want those parole anymore. Yeah, so you know how parole is. They don't want parole, basically. That's just what it means. They want to expedite removal without questions about fear of harm. Yeah, this is crazy. So the Department of Homeland Security begin using a new form. So they have a new form now. Remember when a person is trying to be expedited, removed, you can claim to have a credible fear interview, okay, to where they want to try to remove you. You can request that. But what they're saying is that they have new form when they conduct those interviews. Those new form does not include the questions about fear or concern about returning to the home country of being removed or being removed from the United States. In other words, they have new forms now. So when you do those credible fear interview, they're not going to ask you those questions about fear or concern to return in the country where they're trying to remove you. So it's basically pointless when they conduct those credible fear interview at this point, because if they don't have the question about fear, then what are they really asking? So in other words, they're just trying to, limit asylum. Yeah, asylum is, in my opinion, asylum is pretty much dead at this point. It's just that you really have to have a lot of evidence to convince those immigration judges to win asylum. This is sad. But anyway, what else we have here? So those are the latest immigration news. And remember about the TPS from like Arthur is asking, TPS from Haiti. The judge paused the determination, but just know that this administration has already appealed. So yeah, this administration really want to be done with TPS. They already filed an appeal. Let me see if I can find it here. Yeah, so I'm trying to find if we have a news, if we have other news. That's what I'm trying to find here. Okay, so let's see. By the way, if you're sending your application, for the payment, they have updated their new form, the form G1450. Yeah. So new 6 immigration judges and 27 temporary immigration judges. Yeah. So what else is going on? Nationality. Okay, let's talk about this. Let's talk about this one. Okay. Let me close this one. Do we have a question here? Okay. Only in Maryland, only in the state of Maryland, because that's where I'm admitted in federal court. If the person is interested, they have to email me. Yeah. I don't give out pricing anymore like that. Yeah, they have to schedule a consultation. We have to know what's going on first. Yeah. Only in the state of Maryland, by the way. Only in the state of Maryland. And DC, but most of the time people get DC doesn't have a detention center. People get detained in the holding home in Maryland. Yeah, so I'm trying to get for Texas, but why not only in the state of Maryland? So um what else? I'm trying to see. Okay, hold on. I want to talk about this. Yeah, I wanted to talk about the ban and the pause. We have the ban, then we have the pause. Okay, the travel ban is for the 39 countries, and the pause is for the 75 countries. The pause is for people outside of the United States. Okay. So the ban applied to foreign national. Sorry, let me go. Let me read back up. Sorry, we have the ban, then we have the pause. We have the pause for the 75 countries that apply for immigrant visas for people of those countries who are outside of the United States, processing their immigrant visa. That's for the 75 countries. The 39 countries, we have a ban and we have a pause within the ban as well. Pausing all applications for the 39 countries, and then the ban for people outside from coming. Yeah, the 39 countries has the pause and the ban included. The 75 countries only has the ban on those immigrant visa. Very specific, okay? But just know that some exception may apply for the ban, like certain diplomatic or official visas, immigrant visa for ethnic and religious minorities facing persecution in Iran. That's an exception. They can do that. People who have dual national citizenship and applying with a passport of nationality that's not subject to the ban, they can use their second nationality if they have special immigrant visas for U.S. government employees participating in certain major sports event, lawful permanent resident, the Secretary of Homeland Security, the attorney, if the travel ban will serve for U.S. national interest. That's case by case basis. If it's serving for the interest of the Department of Justice, if your visa or whatever you're asking is for the national interest, then U.S. national interest, then you're not going to be on the ban. If you're going to serve the Department of Justice, then you're not going to be on the ban. Yeah, so that's just something to keep in mind, because it's really confusing. 39 countries, then we have 75 countries. The way to know about it is just like two things, right? Or three. 75 countries apply to immigrant visas for people outside of the United States, like consular processing. The application are on pause, okay? 39 countries, we have the ban and the pause. Then we have some exceptions. That's it. So I think that is my help. Anyways, so yeah, those. So anyways, so those are the, I guess the why I didn't get deferred action under. Yeah, I don't think they sent us. They will send you a separate. It has to be just. It's written on the actual notice. Did you read the notice? Try to read the approval notice. That's when you will see what is written in the notice. Yeah. So I don't think they send separate. That's for SIG. That's when they send separate because the rule has changed. You have to request it. But for that one, I think you just have to basically read the letter, what it says. There's some provision of the law that are cited there that give you that deferred status. Even if it doesn't say it specifically, but that's just how it is. It's like imply basically. but you just have to read that approval notice. It's supposed to say something on those lines, unless they change, you know, every day they changing stuff. But yeah, so it was announced that truck driver will no longer be able to obtain the visa. No longer able to obtain a visa. What I know is that I don't think it's about no longer obtaining a visa. I think the problem was they're not going to get the, unless the person has the green card, or if they don't have the green card, they're not going to get that license, that professional license. I don't know how you call that license to drive the truck. So if you don't have a green card, you're not going to get that license. That's what it says. But it doesn't say that you're not going to get a visa. That's two different things. So in other words, if a person become a lawful permanent resident, then the person can go back and get the license in order to drive a truck. Because I have a client, it's about a visa. I'm not asking about CDL. I'm asking about visa. That's, I don't know about this news. Why did you read it? I don't know about this rule. Never heard that. Yeah, because the green card application does not talk about if you're a truck driver, you cannot get a green card or visa. I don't know about that whole. The only thing I know is about CDL. If you don't have a green card, you cannot obtain CDL. But there's no laws that say that if you're a truck driver, you cannot obtain a visa. No, I did not hear anything about that. The conditions to getting a visa has nothing to do with a person being a truck driver. So the condition to get a green card, they just look at whether the person is admissible or not. On August 25, U.S. Secretary of State Marco announced on immediate pause on issuing new work visas for foreign commercial truck drivers. Alan, I didn't hear that. The visa, the suspension is for everybody, not just specifically. To be honest, I don't know about this particular rule or whatever that is, but um, yeah, I don't know about that. To be honest, if I have to be honest, I don't know about that. I didn't hear anything. Could be true because nowadays everything is possible. They can stop everything. But what I know, there's a pause on those visas, you know, for everybody. There's a pause. USCIS is not processing application for 39 countries because of the pause or the ban, whatever that's going on. If you're not among those 39 countries, then I don't see why they will not issue a visa if you're a truck driver. So I don't know about that whole, to be honest, because the pause applies to everybody, the 39 countries. Yeah. So what else? Do we have additional questions? I guess we talked about all the latest immigration news. If you missed it, just go back to the beginning. Very important, disturbing news. But in any case, we're still here, right? We're doing our best with what we have. So if you have additional questions, you can ask them. Otherwise, we're just going to be here again next Sunday, 2 p.m. Eastern time. If there's a breaking news, I'm still going to recap on it on Sunday, but I might post it on my IG story. But yeah, that's what's going on. You're welcome. I guess that's it. Let's see, do I have something? I guess that's it. Please like, please share. If anybody need a consultation, they can just schedule it. All my links are in the description box. Please like, please share. Or if anybody was wondering about how long it it took to get a green card, or how long it's taking to get a green card based on asylum, for the people who not that are not on the ban, uh, it took for this guy at least, because we applied in 2023, it took at least 2 years. And yeah, 2 years, 2 years. So their green card got, but they had to do the interview. So yeah, it took 2 years. So because I heard somebody was asking how long it takes to get a green card based on asylum after you apply. Yeah, it took 2 years, at least for those particular individual. I don't know for other people. Um, and they're not on the ban. Yeah, and they apply, they got their asylum before, and they did not get the interview, which is good, because now they just like going back to all those cases. But anyway, so this is it for today, right? If you need a consultation, please schedule it. Other than that, we'll be here next Sunday, 2 p.m. Eastern time as usual. That's my schedule. Sunday, 2 p.m. Eastern time. If there's a breaking news, I might come. If not, then Sunday, 2 p.m. Eastern time. In any case, I might recap the news at the end of the week. Okay. Until next time, bye-bye.